Limitation number 2, need for reliance. It is unclear in case law whether the promisee must rely on the promise to his detriment to meet the conditions of promissory estoppel. Recall the facts of High Trees, and you will notice that it is difficult to see how the tenant acted to his detriment by simply paying less money per year. In the post-Chaser 1982, Lord Goff thought that detrimental reliance was not necessary for promissory estoppel. Palm and vegetable oil sold 250 tons of Malayan palm oil to Société Italo-Belge, who in turn sold it to Conte. Under the contract, the sellers were to give notice to the buyers of the ship's sailing in writing as soon as possible after vessel's sailing. In breach of this condition, the sellers were a month late in giving notice to the buyer. This breach by the seller entitled the buyers to reject the oil, but they made no protest to the sellers about the lateness of the notice. On the same day, 10th January 1975, that the buyers received the notice from the sellers, they passed on the notice to Conte. On 20th January, the buyers telex the sellers requesting them to present the documents directly to Conte. This the seller did. Conte informed the buyers that they were rejecting the documents as being out of time, and on 22nd January, the buyers informed the sellers that they were rejecting the documents as being out of time. The sellers had to sell the oil on the open market and obtained only $460 per long ton. They claimed the difference between this price and the contract price of $792.50 per long ton. Although it was held that detrimental reliance was not necessary, but it is easier to show that it would be inequitable to allow the promisor to deviate from his promise when there has been a detrimental reliance. So in simpler words, detrimental reliance is helpful in proving inequity. However, it is not necessary. On the facts of the case, the promisee's position had not been prejudiced by his reliance on the promise, and Justice Lord Goff held that it was not inequitable to allow the promisor to rely upon his strict legal rights under a pre-existing obligation. Note that in Ajayi versus Briscoe, Lord Hodson remarked that promissory estoppel may be induced if other party altered his position on the basis of the promise. The case also established a limitation to estoppel in situation where it is impossible for the promisee to resume his original position. In W.J. Allen and Company versus Al-Nassar 1972, Lord Denning said, "I know that it has been suggested in some quarters that there must be detriment, but I can find no support for it in the authorities cited by the judge." And if you study the cases in which the doctrine has been applied, you will see that all that is required is that one should have acted on the belief induced by the other party.